All right, we'll call to order this meeting of the Advisory Council on Workers' Compensation held in the Tennessee Legislative Plaza today, February 27, 2017, approximately 2 p.m. I'm David Lillard, Tennessee State Treasurer, and I'm chair of the Advisory Council. I'm going to welcome you to the meeting today. And the first thing we need to do is to call the roll, so I'll ask Mr. Scroggs, our administrator, to call the roll of members, voting and non-voting.
Thank you, Mr. Chairman. Mr. Dove, Mr. Fox, here. Mr. Garrett, here. Mr. Hunt. Mr. Hunt is here. Great. Mr. Pitts, here. And Mr. Schaefer. Here. Mr. Burleson, Mr. Denton, here. Ms. Fletchall, Dr. Graves, Mr. Haley, Mr. Harris, he's out of the country, Ms. Lawyer, Mr. Mayo, Dr. Merle, Mr. Ramos, Mr. Shinnick, Ms. Smith. And we have, I know we have Representative Eldridge present. You have a physical quorum.
All right, thank you very much. I want to recognize Chairman Eldridge.
And Abby's here also.
All right, and also Majority Leader Mark Norris is here. Glad to have you here. And Ms. Hudgens is recorded as present for the roll, so sorry we missed you there. We'll amend the roll accordingly. I'm also a member of the Legislative Council on Pensions and Insurance, and at about 30 minutes I've got to go next door to be involved in that meeting, so I wanted to give you a heads up on the front end and designate Christy Allen, who's our Assistant Treasurer for Legal for the Treasury Department, sitting down here in the end. She's presided before when I was called away, so she'll begin to take over presiding at that point and everything. All right, the next item would be item number 3, approval of the minutes of the Advisory Council's previous meeting. Let's see, do we have minutes? All right. Be the October 4th meeting. Do we have any comments, questions, et cetera, in regard to those minutes? All right, seeing none, do we have a motion to approve? Have a motion by Mr. Dove. Is there a second? Second, all right, by Mr. Schaefer. Seeing no discussion, we'll just do this by voice vote of the voting members. All those members in favor signify by saying aye. Aye. Those opposed, no. The ayes have it, so the minutes are approved. All right, under new business is our consideration of legislation affecting Tennessee workers' compensation system as introduced in the first session of the 110th General Assembly. Since we've got 2 legislative leaders here today, Mr. Eldridge and Mr. Norris, I'd like to call up, with your permission, the item that's shown on the agenda as HB 0451, Senate Bill 1237 by Eldridge and Norris. So we'll take that first since they're both here today. Who wishes to go first?
Thank you, Mr. Chairman and members. I'm Mark Norris, and on the referenced bill, this is the bill that's really not a workers' comp bill. This is a bill that's really a tort subrogation bill that allows the apportionment of fault, either the employees or the employers, in a third-party action. It's the simplest way I know to explain it. So if there's an attempt to recover from a third-party tortfeasor, those percentages of fault can be determined, even though the employer is protected, the employee is protected, workers' comp has cordoned them off. As a matter of fairness in comparative fault, it allows us to apply those percentages. So it's appropriate that it's here because it arises out of workers' comp, and we want to make sure you understand we're not doing anything to do violence to the workers' comp statute, but it really is a subrogation tort issue. And we have others who are here to speak to it. I guess Mr. Smith and Mr. Summers, if the committee'd like to hear more detail about it.
Okay. Chairman Eldridge, do you have any remarks on the bill before we call on others?
I'd go ahead and defer to the speakers that we have here today to clarify.
All right.
Thank you.
Without objection of the council, we'll give Mr. Jim Summers an opportunity to speak if you'd like to. All right, sure. But Mr. Fox has a question for you, Leader Norris, before we go to Mr. Summers.
It's good to see you.
How have you been?
Fine, thank you. Good to see you.
What has prompted this? I mean, I'm sure there's an event that's occurred, and I'm curious as to what has prompted it because, candidly, doing both tort work and workers' comp work on behalf of injured employees, I have a little trouble with this bill, as you might imagine, because it puts a burden on the employee to, in the tort case, to defend the employer who has no financial interest in defending themselves. And I find that to be a bit problematic, and I was just curious as to what prompted this proposed legislation.
In all candor, it's not what prompted it, but whom, and it's Mr. Summers, and it was actually 3 years ago, based upon his experience with a number of cases for a variety of clients, associated builders and contractors among them, and I don't think it's intended to put any burden per se on the employee. I think I think there is a matter of proof. You're correct in terms of the percentages, but I think a lot of that is actually established before you even get that far. So it's not intended to be burdensome to either employer or employee. But I would let him tell you his stories. Last time I had a matter like this is before we had workers' comp reform. It was in 1987 when I was defending Union Carbide Corporation and an employee's exposure to polyethylenamine, and the prohibitions and the protections that applied were kind of interesting. We took it all the way up to the Sixth Circuit and ultimately won. But when Jim Summers came along a couple years ago, I thought, by golly, what goes around comes around, and this is the place for him to respond. If I could yield,
That would be satisfactory, sure.
We'll recognize Mr. Jim Summers, attorney of Memphis.
Mr. Chairman, members, happy to respond to that question. This came about as a result of several lawsuits that I defended in which the proof ultimately showed that the employer had substantial fault in a particular case. And my client came to me and said, look, the proof right now shows that we have very little fault. It appears that the majority of the fault in this case is on the part of the employer. You're now telling us that unless we can prove 100% back against the employer, I'm going to end up buying this entire claim, which was in the millions of dollars. And I said, unfortunately, that is the current status of the law. And that law has, interestingly enough, when comparative fault was first introduced by the Supreme Court, one of the first cases that went up actually had this very same situation. And the Court of Appeals at that time said it's comparative fault. Of course, we're going to allow the third party to defendant to allocate fault back against the employer. The employer is immune from suit. And that case went up to the Supreme Court, and the Supreme Court says, well, we don't have a problem with that except for the fact that we think it's unfair that the employer can then turn around and come back against the employee and take 100% of the workers' compensation that has been paid out. So what needs to be fixed is the statute. That was 10 years ago, and since that time there have been two more cases. The Troop versus Fisher Steel decision is a particular case where the Supreme Court literally came right back and said, look, this is totally unfair that these defendants are not able to put alleged comparative fault back against somebody who is obviously responsible, and it's unfair that they're having to buy the entire thing unless they can prove 100%, and it needs to be fixed. And so I went to Senator Norris and I said, this needs to be fixed, and here's why. And here we are.
I'm just trying to think of a scenario, and one that's coming to mind is let's say there's an employee from one of the plants in Oak Ridge, near where I live, that was exposed to asbestos and has developed mesothelioma. And there's a claim against the manufacturers of that product.
Yes.
For what is going to be obviously a death claim ultimately. It would appear under this legislation the manufacturer could then assert fault against the employer for allowing the employee to be exposed to asbestos products in the workplace. The employee would have no way to mount that defense on behalf of the employer. Let's say it's Bechtel Jacobs Corporation at the X10 plant. And Bechtel would have no incentive to defend their policies and procedures and work rules that would have avoided that exposure of that employee to the asbestos product. I just have a hard time stomaching that could be where we head with this, and for that reason, I would have a hard time agreeing with this proposed fix.
Of course, that would be a products liability case.
Exactly.
And this legislature, not 3 years ago, added an amendment to the product liability statute whereby it allows a defendant in a product liability case to allege comparative fault against others who may be at fault, including those who have immunity. So that's currently the law in Tennessee as it exists right now, as I understand it, which is that if you're sued in any other capacity, in any other tort, you have the right as a defendant to allege the comparative fault of anybody else who may be at fault, including those individuals or entities or municipalities or architects or engineers or anybody else who may have the defense of statute of repose. And so therefore, they're immune, but they can be brought in and set and put up as an empty chair. Because the whole idea here is that if we're interested in making certain that a defendant does not have to pay for fault that he's not responsible for. And that's it in a nutshell. I mean, all the cases that I'm talking about are the ones where a defendant was being asked to shoulder the entire burden of an accident for which maybe they had 5-10% at fault, and they're being asked innocently to pay for 100% of a claim.
Give me an example.
So I'm a subcontractor. I'm working on a building, and another subcontractor is working in the same building, and they've got an employee, and they're up there working on the ceiling. And so I've been working in this building, and I've left some trash on the floor. The other contractor comes in, they start work. They're not a very good subcontractor, and they give their employee a ladder that has not been maintained. They know it hasn't been maintained. They also give him a ladder that probably he shouldn't be using for the height that he's working. He goes up, he falls, and he hurts himself horribly. He sues me because I left some dust on the floor, claiming that, gee, your dust on the floor is what caused my ladder to go out from under me. I look back and I say, that's not exactly what happened. I think what really happened was that you got on a ladder that your employer gave you that was obviously in bad shape, and you went up, and he allowed you to go up because his foreman was sitting there watching you go up on it. So I think the majority of the fault in this case is probably on the employer for allowing you to go up, and not some dust on the floor or whatever is on the floor. And so ultimately we think in terms of what, 5%, 10% for my dust, 80% for his fault, 20%, 5%. Now you're asking me for my 5% of my dust to pick up the claim for a lawsuit that I didn't have anything to do with, or I had very little to do with. And the only way I'm going to come out from underneath this and not have to pay $1 million, $2 million, $3 million because this guy's really bad hurt is to prove that the employer is 100% at fault. Now, I can go through a series of cases similar to that. Several of them were in Nashville, and I can tell you right now that I'm defending 3 more cases in which every single case I've got some comparative fault back against the employer. And every single case, I'm looking at my client and saying, I'm sorry, due to the current status of the law, pardon me, my French, but you're about to get screwed.
Then why don't we fix it so that the employer at fault can be held liable for those damages?
Because I'm not here to go back 75 years pre-workers' comp. I think there's nothing wrong with the workers' compensation system. I think it works here and in 49 other states. And I'm not here to talk to anyone on this committee and suggest that we do anything to interfere with workers' comp. My bill does not change a single thing. It doesn't affect the immunity of an employer. The employee is going to get all of his comp benefits. He's going to get whatever he's supposed to get for his lost income, for whatever permanent partial he gets, for whatever else going forward. None of that is impacted by this legislation. None of it.
And you've got a provision that offsets the subrogation claim that the employer, at-fault employer, may have back against the employee.
I'm sorry?
Subrogation issue of the employer getting money back from the employee.
To the extent that the employer is found to be at fault, then he loses the ability to subrogate back against the employee to that extent. So if he's 20% at fault, and the employee goes ahead and maybe hits me for 80%, maybe I get 20% back against the employer is only going to be able to get 20%. He's going to take 20% off of his subrogation back against the employee. I, on the other hand, am paying 80%, but I'm not paying 100%, and I'm okay with that.
Okay. You gave me a good explanation.
Okay, other questions, Ms. Summers, Chairman Eldridge.
Thank you, Mr. Chairman. Just to clarify that, as it says here, the bill does not change the no-fault recovery by an employee in the workers' comp claim against his employer. Is that a correct statement?
That is correct. Nothing changes.
So nothing's changing.
He gets hurt on the job. It doesn't make any difference what he was doing, unless
Right.
he was drunk or one of the other exceptions written into the law. But I mean, if it's just a normal garden variety accident, and maybe he was at fault, but he walks in there and he gets his comp. No
Correct.
change. We're not changing anything.
That's
And by
what
the
I-
way, while I'm here,
Thank you.
and before I sit down, we did go back and go to the National Compensation Commission on Compensation Insurance to determine how many third-party claims there are annually. I went back over 5 years, and there's like 1% or less of all the claims that occur every single year for the last 5 years result in a third-party claim. And it's like 2.2% of those claims in which somebody has lost time. So the world has not come to an end as a result of third-party claims.
Okay, any further questions? Yes, sir.
Sir, I got two issues that I just wanted to ask you about. One, it's the empty chair that bothers me. I mean, how am I supposed to explain to a client that I represent? I do plaintiff's work, workers' compensation out of Lebanon. And how am I supposed to explain to the client that I've got to defend the employer against a defendant's position of comparative fault? Can you address that first?
Happy to. I've been doing this for 40 years. And for 40 years, I have been defending cases in which there was a workers' compensation component, even though I'm probably defending somebody else and so for 40 years, we've had an opportunity ever since we had comparative fault and ever since the Supreme Court ruled and said, well, you're going to have to do 100% or you get zero in terms of comparative fault. Remember when we talked about that earlier? In other words, I've got to prove but for the fault of the employer. I don't have to, we won't owe anything. So in every case, just about that I defend, the first thing I do is I point a finger at the employer and I say, I'm not sure where the proof is going to lead, but as far as I'm concerned, you are 100% at fault. Hadn't figured it out yet, but you're 100% at fault. So I can assure you that all the way through most litigation, if there's an allegation that the employer is 100% at fault, which is something that we routinely do, just because we're covering our bases relative to all defenses that we might have, that plaintiff's lawyer, he better be in there defending and showing what a wonderfully safe operator the employer was, and while we're at it, what a wonderfully safe employee he represents. So, I mean, that doesn't change. I mean, it's not like you're going to go out there and, every case I've ever had in which I've done this, especially on the larger cases, the plaintiff's employee was doing everything he could to defend them. But when you talk about doing what you can to defend, aren't we really just talking about cross-examination to basically set somebody up? If I've tried to cut their legs out from under them, he brings them back and rehabs them. Isn't that what we're talking about?
Well, not when you're talking about the defenses that are going to be alleged in the workers' compensation claim, such as wrongful misconduct, or in a situation where you've got a DUI case, where you've got a defendant that's hit someone or an employee that's been injured, yet the defendant may allege that the truck that was being driven by the employee was failed to be maintained by the employer. That's the problem that I see, is that you're going to put the employee in a position where they're going to have to take a position to defend the employer in the tort matter, but then you're going to have them over here in the workers' compensation claim trying to say, oh, I'm entitled to benefits regardless of the defenses that the employer is being raised, that's being raised by the employer.
With all due respect, Mr. Denton, what you've done is you've flipped the the fault here. I mean, if in fact I'm driving down the street, or your daughter's driving down the street tomorrow, she's doing 58 miles an hour in a 55 mile an hour zone, and some employer has allowed his employee to get in a truck or a car that hasn't been well maintained, and he knew about it, and he let that kid go out there in that truck anyway, and that kid blows a stop sign, and your daughter runs into the side of that kid, hits him on the driver's side, and does an unbelievable amount of damage to that kid. First off, your daughter's going to be sued for what reason? Well, when they downloaded the electronic data module, first thing they found was that she was speeding. She was going over the speed limit. So you're now being sued for the negligence of your daughter. Under the current law, unless I can demonstrate that the employer was 100% at fault, which is pretty much impossible now that we know that your daughter's at speeding, you've just bought that $1 million, $2 million claim for the incredible damage done to that driver, that employee in that vehicle. And that's the current status of the law right now. And it doesn't apply just to contractors. It applies to every single human being who lives in the state of Tennessee who has the misfortune of getting into an accident with somebody who just happens to be an employee.
Sir, that's what I'm talking about right now. I'm not making this up. I've got 2 death cases and 1 case that involves 3 people that were injured by drunk drivers, that this would directly impact their ability to recover benefits under the workers' compensation matter and the claim, as well as having to defend the employer in the tort matter.
Well, we have 2 issues here, because what I just gave you was garden variety tort law. I could care less about the comp side of it. In the situation I just gave you, all I know is that I'm being sued by a kid who's driving a truck and the brakes didn't work and he went through the stop sign, and I'm defending the kid who unfortunately was going a little bit over the speed limit. So the argument's going to be that the kid, if it hadn't been going over the speed limit, might could have stopped or avoided the accident, or maybe it wouldn't have been quite as bad. So that's my concern. And I'm representing the kid and you, because it's your daughter, who's just gotten sued for $2 million or $3 million or whatever we want to go to. And so my concern is not whether or not the boy driving the truck is going to be able to get his comp benefits, because he is. He hasn't done anything. We're not talking about comp benefits. This legislation changes nothing related to his ability to get comp benefits. He walks in the door or goes in on crutches and he says, I've just been in a terrible accident, which you know about because you all are now paying for the medical and hospital bills since I was on or about the business of the employer at the time this occurred. And so he goes on and gets all of his comp, he gets his TTD, he gets permanent partial, whatever he gets. It's got nothing to do with me. I'm sitting out there waiting to get sued. And then ultimately he's going to sue me. He's going to sue your daughter. And I say me, but he's going to sue your daughter, and then he's going to sue you because she was driving with your permission and a car owned by you, and now you're going to be sitting on the hook because maybe your daughter is 5% at fault, and they're going to be looking to you for the other, 90. I mean, you're going to be looking to you for $3 million because you can't get to 100% on the employer because you're already partially at fault. And that's what this is all about, comparative fault. We got 1 bucket of fault. Everybody only pays their fair share. So do you want to pay $5,000 or $50,000 on a $1 million claim, or do you want to pay the whole $1 million?
I appreciate the comment, but, I do care about the fact that it's workers' comp because that's what we're here to deal with.
And I understand that, and I didn't mean that in a bad sense. I'm just talking about from the standpoint of me defending a case. I am not thinking when I'm representing my client, who's being sued. The issue is not whether or not your client is going to get workers' compensation as a result of this accident. To me, the issue is whether or not my client has to pay for an accident that she is only 5% at fault at, well, not 100%. And that's what this is about. Thank you.
Mr. Ramos is recognized.
Thank you. Mr. Summers, as I hear the questions, the thing I hear that people are uncomfortable with is that in that third-party tort lawsuit that the employee might bring against the third party, the employee basically is placed in the situation of defending the employer, as you acknowledged. I've just got a practical question. Right now, it looks like the employer really has no incentive to intervene in that lawsuit to defend itself. I understand that its subrogation interest may be proportionately decreased by the percentage of fault the employer ultimately is determined to have. Is there any practical way basically to get that employer to defend itself in that third-party lawsuit and perhaps by strengthening its subrogation interest, to kind of guard against a reduction in its subrogation? Is there I'm just curious if you know of any other efforts from other states who also have comparative fault. Is there any other practical way to get the employer in to defend itself in that third-party lawsuit so the employee is not placed in the position of having to defend the employer?
Mr. Ramos, I can't speak for everyone, but I can speak from my own experience. And as the amount of compensation that is paid out by an employer increases, so too is the likelihood that the employer will have a lawyer who's not only filed a petition to intervene, but who shows up at every deposition. And it's in their best interest to get 100% back, because that's how they're getting paid. So it's been my experience that there's always somebody there to protect the employer's interest, and I can assure you that if this bill passes, we will see even more. But right now, I can't think of a single case that I've handled, certainly out of the ones that I brought to Senator Norris, and that I've used as examples before this committee, in which the employer didn't already have a lawyer in place. They're there not only during the depositions, they're asking questions, and they're at mediation. And for the ones that I've tried, they're sitting there at trial as well. So this is not where they're just all of a sudden not having any idea what's going on. And if your subrogation is at risk, and you're the insurance company, typically they're the ones that retain the lawyer to show up. I can assure you that if the subrogation is at risk, because I've got an allegation that their employer's at fault, they're going to have somebody there, and they're going to be defending, and they're going to be pushing money towards to assist the plaintiff, because that's the other part I deal with, is that and it's fine. I don't have a problem with that. But typically the employer/comp carrier shows up, and not only are they the defending, but they're also helping to finance the lawsuit because they want their money back. So it all seems to play out in terms of fairness. Everyone is represented.
Mr. Fox is recognized.
Would you be amenable to considering or discussing an amendment that would say if the employer is found to be 50% at fault or greater, they have no right of subrogation? That would certainly incentivize them to defend. You get what you want.
I don't have a problem with that, but I'm not speaking for the world.
Well,
in terms of my legislation, I don't have a problem with it.
Leader Norris.
Thank you, Mr. Fox. I certainly for our purposes here today, I would be willing to consider that. That gets us even further outside the workers' comp realm, however, and I'd have to consider, other players and other other considerations. But to the point that's being discussed here, it's in keeping with the philosophy that brings us here. So it's a good question. I'd be willing to consider that in that sense. I have no idea what the plaintiffs bar and the defense lawyers and everybody else would think, but it puts it in the right arena. I mean, in terms of the
Would you
tort.
be willing to roll the bill to our next meeting and let's have that discussion to see if, I mean, I've not thought it through fully myself, but
Yeah.
it seems to me, like you state, in the term that we're here under, and in the context of the tort law, that's sort of consistent with now. If you're 50% or greater at fault, you don't recover if you're the plaintiff. So why should an at-fault employer who's 50% or greater in causing the harm get any money back under our current system? That's the way it is.
I don't have any objection to that as long as the committee doesn't object to our starting to work on a bill that really, that work is not going to be done by the Workers' Comp Advisory Council. It's because what we're doing does not adversely affect workers' comp. But I mean, as a courtesy, I don't have a problem. I just don't want to get too gummed up where the advisory council says, here we are in year 2. There are lots of angels to dance on the head of various other pins when we get to the rest of the General Assembly. This is the kind of thing that might come up in the Judiciary Committee, for example. Put it in. I'm just not sure how germane it is to comp. It's germane to you and me, and if it's germane to you, I want this to get a favorable recommendation out of this committee. If you think that'll help, but it may actually encumber it in some ways that the other members don't feel comfortable with. That's my concern. I want to start fighting those other battles that aren't properly.
It would help me.
I want to help you, Brother Fox. I want to help you. I want you to help me. If you think that would help me, when's your next meeting?
We haven't scheduled the next meeting yet. We got a tentative date. What's our tentative date, Larry? Do we have this? 2 weeks from today is the tentative date.
But, Mr. Chair, do you think that's going to raise objections by members of from a workers' comp standpoint that we're getting far afield and things they're not comfortable with? I mean, it doesn't really affect the comp aspects of this at all.
Well, I think it would be good to have some more consideration of the elements of the bill, and so my advice is to roll the bill. But
well, and I'm happy to ask for that at the member's request. But I'm mindful that we're getting this is like Judiciary Committee stuff, not workers' comp stuff.
Okay. Without
2 weeks.
objection, we'll roll it to the next meeting. Mr. Pitts.
I realize the bill's been rolled, but among you pontificators, if you all were seriously going to look at the 51% issue, are you asking that if you went in that direction, does it come out of this committee and just go to the judicial committee? Or are you still wanting it to come through workers' comp? Or do you have an opinion?
I just know I can't get to judiciary until you all opine in workers' comp.
Well, that's why I'm thinking it's sort of nice to know if we have any thoughts here today to help you in your processing.
All right. Without objection, bills roll 2 weeks, or rather the next meeting, to the next meeting, which would be in 2 weeks, whenever that happens to occur. It could occur a little sooner than that. So
I appreciate the question, Mr. Pitts.
I was hoping that I might get a little feedback from some members of the committee of how they were reacting to this. Mr. Chairman, could we hold just a minute and see if the other side of this bench up here has a collective thought? Mr. Fox?
all right, we'll stand in recess for 3 minutes. All right.
Are you receptive to the thought that if he takes your amendment? Pardon?
All right, we'll reconvene the council from our short and brief recess, and then as the first order after our reconvening, without objection, the roll that the chair announced earlier will be withdrawn and the matters on the agenda. I assume there is no objection from any member. Mr. Pitts, you're recognized, or Mr. Fox, whichever one wishes to talk about the issue.
Senator Norris, I would move that you agree to amend your bill to include language that basically that says that the employer, if allocated 50% or greater fault, has no right of subrogation. With that amendment, we would support your bill.
All right, I'll do it.
All right, so that's a motion, is that right? Well, first of all, let's move to get the bill on the floor itself. All right, do we have a motion on the bill itself? Does that incorporate that to move it out with a favorable recommendation with that amendment carrying with the bill?
That would be our motion, yes.
Okay. All right, is there a second for the motion?
Mr. Chairman, I'll second.
All right, Mr. Pitts seconds. The matter's open for discussion. Any discussion on the motion with the amendment carried with the bill as proposed by Mr. Fox? Any discussion? All right, for the final time, Mr. Clerk, would you call the roll of the voting members on the motion with the amendment attached?
Mr. Dove. Mr. Fox. Aye. Mr. Garrett. Aye. Mr. Hunt. Mr. Pitts.
Aye.
Mr. Shaver.
All right. It's unanimous in support of the motion, so the bill goes out with a favorable recommendation with the amendment attached.
Thank you all very much.
Thank you very much,
Appreciate it.
Leader, and
Thanks, Mr.
thank
Fox.
you,
Thank
Chairman Eldridge. All right, the next item that we'll call is the other matter involving Leader Norris, which is House Bill 0325 and Senate Bill 1214 by Hawk and Norris. And I understand Ms. Hudgens, a member of the council, has a presentation on this bill or some discussion. Oh, Mr. Haley does. Okay, with respect to this. Before we get to that, I want to recognize that Representative Mark Pody was with us a minute ago. I guess he had to leave. And Representative Ron Gant is here, Fayette County. Glad to see you, Ron. See who else we got here. Wait. Oh, Mark. Jay Reedy. Oh, okay. Here we go. Jay Reedy's here. Representative Reedy. Okay, I didn't see you over there. All right, very good then. We want to recognize them. And I'm going to turn the chair over now to Ms. Christy Allen because I've got to go to the Legislative Council on Pensions and Insurance, and Ms. Allen, Assistant Treasurer, will preside for me. Thank you.
Mr. Pitts, you're recognized.
This question is for the presenter. The question is for the presenter, but I'll be happy to hear from you if you'd like.
I'd like to introduce the presenter.
All right, my question for you is you're going to make a brief presentation.
Yes, sir.
Then you're going to ask that this bill be rolled. Is that correct?
That's correct.
Thank you, sir.
Thank you. I'm Troy Haley, attorney and legislative liaison for the Bureau of Workers' Comp. Leader Norris, thank you. Just like Mr. Pitts said, I'm going to go over the talking points and summarize. And we've been working with some sponsors on an amendment, so but I appreciate your time. And thank you. Right. Senate Bill 1214. House Bill 325 is the Bureau of Workers' Comp administration bill this year. I'll kind of highlight for you, and again, we're working with some sponsors, working with the constituent groups and some representatives on an amendment to the bill. I've been telling everybody I've got 4 goals of this legislation. It's actually 5 on this bullet point list, but I combined the last 2 into one. So what we'd like to do, and our purpose in this legislation, is to eliminate some unnecessary form filing, to establish vocational recovery assistance for injured workers who were hurt on the job but were not able to make a meaningful return to work, address some time frame issues with the Workers' Comp Appeals Board, and to provide an opportunity for oral argument to the Appeals Board. And then lastly, fines for failure to provide proof of workers' comp coverage, failure to or entering false information on the application to the Secretary of State's exemption registry. So the first goal of the bill would be to reduce the form filing requirement on several of our coverage forms. We've worked with some of the constituent groups. They've expressed some concerns on us eliminating the form entirely, so we're going to amend the bill to still have the form available on the Bureau's website, but we will no longer be collecting and retaining those forms. And I asked the coverage coordinator this morning how many of those forms we get per year. The estimate was about 1,800 per year, and he said that about 1,000 of those were filled out correctly, and the other 800 were filled out incorrectly and had to be sent back for additional information and correction. So it's been quite a task to keep up with all of those forms. The forms will still be available. They can be exchanged between the parties, the insurer, the agent, employer, but the Bureau will no longer be responsible for retaining the form. Second goal, and these are not in the exact same order as I went over them earlier, but second goal, fines from $50 to $5,000 if there is not proof of coverage at a job site, or if there's wrong information knowingly presented on an exemption registry application. There was some concern about the range of the penalty being too great, and we tentatively agreed on sort of a two-tiered first offense fine, and then the second offense would go up to $5,000, but that would have a little bit lesser an impact if it's a situation where a first-time offender, it was just a glitch in their bookkeeping process or something like that. Third goal, the Workers' Comp Appeals Board will have 20 days instead of 7 days to issue their determinations. That's still the shortest in the country. The 7-day period, as most of you will remember, is a carryover from the pre-reform statute where the administrator's designee in the administrative review process had 7 days to issue a determination. Also, there'll be a oral argument opportunity at the discretion of the appeals board in this new provision. And last, education benefit. We've proposed a vocational recovery program. The maximum on that would be $5,000 per year per individual. We've also been asked to put an aggregate limit for the whole, for a particular calendar year, and we've agreed to do that out of some concerns that the monies from the Second Injury Fund might not be sufficient to cover those applications. Be happy to try to answer any questions.
Mr. Pitts is recognized.
Did you all not also agree to, or I didn't hear anything, isn't there a maximum amount of time, like either 2 years or 4 years, or might be worth telling people that?
You're correct. We were asked to amend the bill to put a sunset provision in the vocational recovery assistance program, and we've agreed on 4 years, I believe is what we agreed on. It's a year. It's going to take a year to get the rules in place and the program set up, and then 3 years beyond that date would be the sunset.
But also on the $5,000 per year, is there not a limit on that, the number of years, like 10,000 for a 2-year vocational school, or 20,000 for a 4-year?
We're certainly agreeable to
Have I
working
not,
on that.
Was that not a part of the original plan?
There is a $5,000 per year stipulation, and we have been asked potentially for a $500,000 aggregate cap per year for all injured workers under that program. But as far as each one, the number of years or the number of dollars per individual, we're open to talking about that. But I think in my most recent revised draft that I did this morning, that's not in there. We can visit about it, though, if you'd like.
Okay, thank you.
Any comments or questions from other members? Seeing none, thank you. Mr.
Right.
Haley?
Thank you.
I think the next item for consideration is House Bill 580, Senate Bill 932. I believe Representative Reedy is here for that. Whenever you're ready.
Mic is hot now. All right.
All right. There we go.
Representative Jay Reedy, House Bill 580. Firefighters Cancer Disability Presumption Act is what we're naming the bill. Currently, we're standing in the county as well as the city that already has this on their books, helping firefighters. And of course, the layout is it's just presumptive. In other words, the firefighter has to have 5 or more years in service. With that, he has to prove that the cancer came from his occupation. At the same time, it requires medical pre-testing done by the employers. And I do have Kathleen Murphy here. If I hit a speed bump, that she can certainly take questions as well. Madam Chair.
Thank you, sir. Thank you, sir. Any questions or comments from the members of the council? Seeing none, is there a motion from a member of the council? Mr. Fox, you're recognized.
I would move that we pass the bill.
Is there a second?
Meaning vote on it. Recommend it.
So the motion is to,
Recommend the bill.
with a positive
vote.
recommendation.
Yes.
So that is the motion. Is there a second? A second by Mr. Schaefer. All right, it's open for consideration. Members of the council, Mr. Pitts is recognized.
Madam Chair, I hate to do this, but in my years of involvement with workers' comp, we have on repeated occasions had an interest group bring a bill to create a presumption. And I just frankly don't, as much as I feel sorry for cancer patients, I think presumption that it's because of their occupational choice is just not appropriate. For that reason, I intend to oppose the bill.
Any other members of the council wish to comment? Is the council ready to vote? If so, Mr. Scroggs, would you call the roll?
Mr. Dove? No. Mr. Fox?
Yes.
Mr. Garrett? Yes. Mr. Hunt? Mr. Pitts? I'm sorry, Mr. Hunt?
Yes.
Mr. Pitts?
No.
Mr. Schaefer? Yes. 4 votes in favor, 2 votes opposed.
So the bill goes out with a positive recommendation.
Thank you, Chair and Committee.
Thank you, Representative Reedy. The next item on the agenda is House Bill 157, Senate Bill 177. Chairman Eldridge, I believe that's you.
That is my bill. and Bill, the number 3 that we took up, House Bill 325, the Hawk Norris bill, I'm actually carrying that bill, the one that Mr. Troy presented a while ago, so I'll be carrying that bill through the system here.
Okay.
House Bill 157 is actually, I'm carrying that with Senator Ketron. It's just a caption bill. Nothing bad is going to happen to it. It has nothing to do with, opt-out, and we will control the bill. And if we have an amendment that comes on the bill and we move it forward, we're going to make sure we got a recommendation from this committee right here. So we're in good shape. Thank you.
So what is the council's wish as it relates to this bill?
Request to be recognized.
I'm sorry, is that Mr. Hunt? Yes, you're recognized.
On House Bill 580, I seek to amend my vote to a no.
All right.
I'm having a tough time hearing on the phone here, so there's a lot of
apologize.
papers being moved, but if I could amend my vote on 580 to no.
All right, so Mr. Scroggs has retallied the vote, and would you please say what that is?
With Mr. Hunt's change, that would be 3 votes in favor, 3 votes opposed.
So that means the without a
Without recommendation.
at all. Mr. Scroggs will contact Representative Reedy, who has left the room. Sorry, Chairman Eldridge, returning to you on House Bill 157. What are your wishes as it relates
I would
to that?
say, recommend the bill, but we will not move the bill unless, we got clarification on what we're trying to do on the bill.
Okay. Is there a motion to recommend the bill move out? Mr. Pitts is recognized for a question.
Mr. Chairman,
Yes, sir.
I may have missed the first part of your discussion. Did you ever indicate what you might be going to do with this bill?
I'll assure you, you'll be happy with it. You'll be happy with it. And I'll assure this committee here and the chairman and chair lady that we will not move this bill if it has anything to do with anything negative to our industry, or especially if it has anything to do with opt-out. As far as I know, opt-out on workers' comp is off the table because of the Supreme Court ruling in the state of Oklahoma.
Mr. Chairman, I don't want to beat up on the chairman. It's not wise to do so. Typically in this committee, I don't think we've ever carte blanche reported out a caption bill. Would you have a problem with the fact that we'll probably have 2 or 3 more meetings, that you might save that to a subsequent meeting and see if this gets fleshed out a little more?
Oh, I'll be glad to save it.
Okay.
That's fine. That's fine. That's safe.
So without
I
objection,
think it'd be a little safer
objection.
for all the parties.
Sure.
Thank you, sir.
Thank you.
so without objection, we'll defer that bill to the next meeting and see where we are.
That'd be fine. See what happens.
The next item on the agenda is House Bill 666, Senate Bill 297. Is there anyone here to? Okay. I'm told that Sarah Adair is here from Senator Briggs's office to speak on this bill. Okay. Mr. Fox?
We've been in touch with Senator Briggs. I understood Sarah would be here from his office to move on behalf of the senator to roll the bill. And that's what I would like to propose, that we roll the bill and give us some time for further discussion.
Roll the bill to the next meeting, next scheduled
Yes,
meeting?
to the next meeting.
Without objection, that bill will be deferred to the next meeting of the council. The next item on the agenda is House Bill 939, Senate Bill 261. Is there anyone here to present this bill? Okay. Please come forward and make sure the mic is on and state your name and who you represent.
Good afternoon, members. Michelle Consiglio Young, Assistant General Counsel and Legislative Liaison for the Administrative Office of the Courts. Representative Carter was supposed to present this today, but he is in budget hearing, so I told him this morning that I can take up the slack and get it in front of you all, since this is a Tennessee Supreme Court bill. So I don't know how much you all have looked at it, and I did not know until this morning that I would be here presenting it to you all. Otherwise, I may have had a little bit more to give you on it. But anyway, basically, the AOC, Tennessee Supreme Court, worked in conjunction with the Workers' Compensation Bureau and the administration, the governor's administration, to try to make less duplicative the appeals process for workers' compensation cases. So basically, this is coming out of a concern that right now in the law that there are 2 different methods of going about appealing your workers' compensation orders. The one being going through the Workers' Compensation Appeals Board, and then another just waiting until that compensation order becomes final and then going straight to the Supreme Court. So that has resulted in a mix of different orders and opinions from the Supreme Court, and they would like to make this a little bit more efficient and effective. So anyway, what this bill aims to do is to essentially mainstream it and say you will have to go through the Workers' Compensation Appeals Board first, create a discretionary appeals process through TRAP 11, through Rule 11, just as any other case would go through to get to the Supreme Court for appeal, and then the Supreme Court would take it, like I said, upon a discretionary appeal. So that's pretty much the gist of it, and then there are several changes that have to be made within Title 50 to accomplish that.
Thank you. Do members of the council have any questions or comments? Mr. Fox is recognized.
At the risk of embarrassing myself, what is your due date?
Oh, you're fine. It's May 15th, so hopefully the legislature will be done by then, and hopefully this bill will either have gone out way before then, or we come back next year and deal with it. So
I have 5 daughters, 3 of which are pregnant right now.
there's something in the water this year, apparently.
It's terribly unfair for them to send you down here for us to then have to deal with you on this bill as opposed to Representative Carter.
I can handle it. Trust me.
Does this legislation not take away the right of appeal and make it discretionary? Isn't it an appeal as of right now, both avenues?
It is doing away with the as of right, the automatic, going to the Supreme Court. So it is going to take away that, but it's not replacing it with no avenue of appeal. It's just going through so that it will have to go through the appeals board and then discretionary review to the Supreme Court.
I could support it if you had to go through the appeals board and still had a right to appeal, non-discretionary. Otherwise, I would have real problems with taking away the right of injured workers. And I think, I may be wrong, but I think you may hear that employers also feel that way.
I understand. We've heard a few rumblings on it. Nothing actually directly. We haven't been asked directly about it. Figured that would probably come out in this meeting. But the way that the court looked at it, they thought that this would still not impede anyone from getting to them. It's just going to have it go through the process that any other case goes through, and if they deem it worthy and they say that the Workers' Compensation Appeals Board that they want to review that they will take it. Otherwise, what the appeals board, as you know, says would stand, and they feel like that is a fair way for these cases to be dealt with on appeal.
My position hasn't changed on the right of absolute right of appeal for an injured worker or an employer in a workers' compensation case.
You would have the right, obviously you would go to the appeals board, but it would not be the direct right to the Supreme Court. Correct.
Mr. Pitts is recognized.
This may need to stir for a while, because today I believe the employers have the same concern. I'm not sure that anyone would object to a requirement that it go through the Workers' Comp Appeals Board, but there's a great reluctance to give up the right to a final appeal to the Supreme Court. And I'm being led to believe that during the past year, very few cases have gone to the Supreme Court, so I can't imagine it being a workload issue. So I guess at this point, the court hadn't done enough to convince us this is a move that ought to be made, but I think that's where we are at the moment, if you had to call for a vote today.
Mr. Ramos, you're recognized.
Can I ask for a point of clarification? Because I don't understand exactly the concern. Are you saying that even though this legislation that is proposed would provide a requirement that it go to the appeal go first to the appeals board,
Correct.
it would remain a right to ultimately go to the Tennessee Supreme Court?
Yeah, it would obviously remain. It would be discretionary appeal. It would be like any other case going to the.
It would be a discretionary appeal as opposed to an appeal of right.
Right.
Okay.
Right now, it automatically goes.
Right.
So that is going to be the change. That you obviously will go. You will go through the appeals board. Unlike having the two different options now, so you appeals board and as your intermediary appellate court, basically, and then discretionary.
I think you've answered my question because you're talking about the ultimate appeal to the Supreme Court, Tennessee Supreme Court,
Correct.
as being a discretionary appeal as opposed to an appeal of right.
In the way that the court, when this was discussed, looked at it, and obviously it's different than the regular just cases, but that the Board of Appeal, the appeals board, is basically your intermediary court.
Sure.
So just because of the way it's all been changed in the past few years. And it's more of an efficiency issue on their end and not so much not trying to keep people out of the court. It's just to make this process more efficient and in line with how other cases go through appeals process.
So at least as I'm understanding it and hearing everything, everybody is on board or can be on board as long as it's clearly established in this proposed legislation that the ultimate appeal to the Tennessee Supreme Court remain an appeal of right as opposed to the discretionary appeal.
And if that is, what you all are, that's what I'm hearing from you all. And I will be happy to share that with the court. And if that is kind of the consensus, what I would ask is if I could go ahead and do that, talk to them, come back at your next meeting and have another discussion about this.
So I'm hearing that the council would like you to do that and take some more time with this. The sponsors of the bill are not here.
They are not.
So given that it would take a vote of the council to defer the bill. So is there a motion to that effect? Mr. Pitts makes a motion. Mr. Fox seconds. I think we could do this by voice vote. All those in favor say aye. Aye. Opposed? All right, the bill will be deferred to the next meeting of the council. Thank you. Okay. All right. Mr. Scroggs reminds me that there may have been some members of the public who might have called in with a desire to make comment. I don't think I've heard from anybody except Mr. Hunt. If there is anybody on the line, though, other than Mr. Hunt, this is the time to let us know. Okay, I don't hear anybody from that. Is there any other business? Chairman Eldridge.
Madam Chairman, could you just go over what we've done, the action of each bill, make sure we're all together on that? Because I don't think we got a lot of bills out here today.
I will defer to Mr. Scroggs for that summary. Mr. Scroggs.
Give me just a moment here. Let me make sure what I'm doing here. Just to skip down to House Bill 451, Senate Bill 1237, Eldridge Norris. That bill was unanimously supported in terms of recommending that bill as amended. House Bill 666, Senate Bill 0297, Hill, Matthew, and Briggs. That bill was rolled till the next meeting, as was the bill right below that, House Bill 939, Senate Bill 261, Carter Johnson. That was also deferred to the next meeting. The administration bill, which was House Bill 325, Senate Bill 1214, Hawk Norris, that bill is also deferred. Your bill, Mr. Chairman, House Bill 157 and Senate Bill 177 has also been deferred. That's a caption bill. And then I think 580, 931, I think that's the bill, Mr. Representative Reedy, Senator Catron, that bill was voted out without recommendation.
Thank you, Chairman Eldridge. Is there any further discussion, any further items of business before the council today? Just one logistical item. I think we are going to try to schedule the next meeting in 2 weeks or less. Probably looking at 2 weeks.
If we look at 2 weeks with the 13th of March, what would be the time?
So tentatively, I think we're looking at March 13th. So please look at your calendars. Let Mr. Scroggs know as soon as possible whether you're available so we could find another time if you are not. So, okay, you are not. Okay. Don't know, afternoon. He'll be in touch. So is there any other business to come before the council today? All right, hearing none. Council is adjourned until call the chair. Thank you.